everyone. Welcome to Legal Connect, the space where we tend to analyze and look in depth at some of the legislative uh, pronouncements in Nigeria, some of the bills that have been passed into laws. At the last episode, we were looking at the Money Laundering Prevention and Prohibition Act 2022. If you want background information about the law, that's a piece of legislation, I would recommend that you uh, listen to the episode before this one in order to have a good background knowledge of what was discussed. As promised, today, the second part, or this is a part two continuation from the previous episode, and also we are going to be looking at the trending story in Nigeria, or trending news in Nigeria at the moment, which has to do with the new currency introduced by the Central Bank of Nigeria. I'm just going to give opinion on that development. In the meantime, we are going to be looking at Section 5, from Section 5, hopefully Section 6 and 7, if time allows, to look at what the provision of those sections are in relation to the money laundering law. As I stated from last episode, this piece of legislation is fairly new. It was enacted this year as the tie to states 2022, and it was around May of this year that this legislation came into law. So before I dive into Section 5, I just want to encourage my listeners that they should endeavor to sign up to this space in order to get notification of new episodes that we've uploaded or posted. So in the meantime, like the program, like the episode, provide your comments, and above all, sign up to be part of this space or platform. So Section 5 of the legislations, the title is Duties Incumbent upon Casinos. So Section 5 deals with casinos in Nigeria. And not just casinos in Nigeria, it also deals with casinos onshore, that is in ships and yachts. So, Section 5, subsection 1, a casino shall verify the identity of any of its customers carrying out financial transaction by requiring its customer to present a valid original document bearing his name and address, and record all transactions under this section in chronological order, including the nature and amount involved in each transaction, and each customer's surname, forenames, and address in a register forwarded to the Special Control Unit against money laundering for that purpose. A register kept under subsection 1b shall be forwarded to the unit and preserved for at least 5 years after the last transaction recorded in the register. In this section, casino includes internet casino and ship-based casino. So that is Section 5. Just going to analyze, give my opinion on this section before we move on. Section 5, it is all about casino. And you remember from last time, the limit an individual can spend in regards to cash transaction is 5 million or its equivalent, or a company, the limit that they can spend on cash transaction is 10 million. So if a company or an individual decides to engage in casino betting or playing casino, playing the roulette, they are required, the business, the casino now is required to obtain informations from their customers. Uh, and those information includes a valid original document. I think they will be taking a copy of those documents, the name and address, and required to present these to the Special Control Unit Against Money Laundering. This is the arm of the EFCC that deals with money laundering. It is quite straightforward, Section 5, but the concern that I have in relation to these section is the amount of data harvesting that the EFCC or the government in this situation are putting on the shoulder of these businesses to harvest, because collecting personal data is data harvesting, and they are required to forward these data to the Special Control Unit Against Money Laundering. Personal information or data information of persons are very, very essential. They are very sensitive, and having the casinos to obtain these data are their requirement for them to protect this data. That they and I don't know. I have to look at the data law and see what businesses are required to do in order to protect the data of their customers and people that patronizes them. And also the Special Control Unit, they are going to be storing a huge amount of data, personal information of people. If you look across the Western world, data harvesting is a serious issue. You hear of cloning of people's identity theft, and all the likes. But Nigeria is collecting a huge amount of data for the purpose of money laundering. And not just the special control unit that are gathering this data, they are requiring casinos to gather the same data as well. It is not obvious here what measures are required by data controllers to prevent leakage or hacking onto their system in order to obtain these data. So it is quite straightforward, Section 5, which talked about you have to collect this data and you have to pass it on to the Special Control Unit. They will keep those data for 5 years. It is not only for those casinos on land, even ships that sails from Nigeria, I believe, or that are subject to Nigerian law have to collect this data. And those data could include data of foreign dignitaries or foreigners if we are to interpret this section to the latter. So let's move to Section 6. Section 6. A designated non-financial business and profession whose business involves cash transactions shall, in the case of a new business, before commencement of the business, and an existing business within 3 months from the commencement of this act, submit to the Special Control Unit Against Money Laundering a declaration of its activities. Prior to any transaction involving a sum exceeding $1,000 or its equivalent, identify the customer by requiring him to fill a standard data form and present his international passport, driving license, national identity card, or such other documents bearing his photograph as may be prescribed by the Special Control Unit Against Money Laundering, and record all transactions under this section in chronological order, indicating each customer's surname, forenames, and address in a register number, numbered and forwarded to the Special Control Unit Against Money Laundering. The register kept under subsection 1 shall be forwarded to the unit and preserved for at least 5 years after the last transaction recorded in the register. A designated non-financial business and profession that fails to comply with the requirements of customer identification and the submission of returns on such transaction has specified in this act within 7 days from the date of the transaction commits an offense and is liable to conviction. 2. A fine of 250,000 naira for each day during which the offense continues, and suspension, revocation, or withdrawal of license by the appropriate licensing authority as the circumstances may demand. So let's analyze this section. Let me just quickly get this off my chest before I analyze section 6. Section 6, subsection 1b, there is a stated 1,000 US dollars. Why would a Nigerian law referring to dollars? Have you ever seen any other country in the world in their law talking about naira? I think it is a disregard to the fundamental importance of naira to the country Nigeria. It is common thing in Nigeria where transactions are calculated in dollars, but for our law to be referring to dollars is an aberration on the country's currency. So I'm not sure why we are referring to dollars in a Nigerian legislation. So that is off my chest now. Section 6 talked about a designated non-financial business and profession. At the last episode, I did mention some of the designated non-financial businesses that has been listed by this piece of legislation, and that list is contained at section 30 of the Act. And some of the designated non-financial business and profession includes automotive dealers, as car dealers, businesses involved in the hospitality industry, casinos, clearing and settlement companies, consultants and consulting companies, dealers in jewelries, dealers in mechanized farming equipment and machineries, dealers in precious metals and precious stones, dealers in real estate, estate developers, estate agents and brokers, high-value dealers, hotels, legal practitioners, notaries, licensed professional accountants, mortgage brokers, practitioners of mechanized farming, supermarkets, tax consultants, trust and company service providers, pools, betting, or such other businesses and profession as may be designated by the minister responsible for trade and investment. So that is the list of the designated non-financial businesses and profession. So these designated non-financial businesses and profession are required if they're just starting up, or it's been 3 months, they have been an existing business and it's been 3 months since this legislation came into force. They are required to submit to the Special Control Unit of EFCC a declaration of what they are doing, basically. So they have to declare to the EFCC, that is the Special Control Unit. They have to declare to them what their business is all about. Any transaction which is cash transaction done by any customer of these designated non-financial business has to be recorded. So they have to identify the customer by requiring the customer to fill a standard data form. So if I were to go into a law practitioner firm and I said, oh, I want to instruct you to act on my behalf, but I want to pay you in cash, and that amount exceed $1,000, I'm not going to convert because I think it is disrespectful of the legislators to be talking about dollars when they are talking about Nigerians. So if the amount is over $1,000 or its equivalent convert to naira, the legal practitioner firm has to take my data. They have to give me a form to complete, present my international passport or driving license, national identity card, or such document that will be bearing my picture, my face, and my name and address. And then those information that have been acquired will now be passed on to the Special Control Unit against money laundering. Fair enough that they are trying to combat money laundering, but requiring all these designated non-financial businesses accumulate data, businesses that I've just listed, how many of them have the required security to protect those data that they are harvesting? And this is not data of 5, 10 people. Over the course of a year, I believe approximately over, if not more than 1 million personal data will be harvested or acquired by these businesses. And does the Special Control Unit against money laundering, do they have the capacity to protect these data from being hacked? That should be a concern to Nigerians. And I'm surprised that the legislators, they've not thought about is the implication of having so much data stored in one place. Also, if my legal representatives failed within 7 days of me instructing them, failed to declare this information to the Special Control Unit against money laundering, they will be charged or fined 250,000 for each day during which the offense continues. Or they could be suspended, their license could be revoked or withdrawn by the appropriate licensing authority. For my legal representative, we're talking about, I believe, the Nigerian Bar Association. They can take away the license of my legal representatives. While I'm concerned about the amount of data that will be stored, I think it is a good thing that businesses are required to carry out due diligence. Section 7. This is suspicious transaction reporting, where a transaction involves a frequency which is unjustifiable or unreasonable, is surrounded by conditions of unusual or unjustified complexity, appears to have no economic justification or lawful objective, is inconsistent with the known transaction pattern of the account or business relationship, or in the opinion of the financial institution or non-financial business and profession, involves the proceed of a criminal activity, unlawful act, money laundering, or terrorist financing, that transaction shall be deemed to be suspicious, and the financial institution or designated non-financial business and profession involved in the transaction shall report to the unit as the case may be immediately. A financial institution or designated non-financial business and profession shall, within 24 hours after the transaction referred to in subsection 1, draw up a written report containing all relevant information on the matter mentioned in subsection 1, together with the reasons and identity of the principal and, where applicable, of the beneficiary or beneficiaries. Take appropriate action to prevent the laundering of the proceeds of a crime or an illegal act, and report the suspicious transaction and action taken to the unit. The provisions of subsection 1 and subsection 2 shall apply whether the transaction is complete or not. The unit shall acknowledge receipt of any disclosure, report, or information received under this section and may demand such additional information as it may deem necessary. The acknowledgement of receipt shall be sent to the financial institution or designated non-financial business and profession within the time allowed for the transaction to be undertaken, and it may be accompanied by a notice deferring the transaction for a period not exceeding 72 hours. Notwithstanding the provisions of subsection 5, the unit or the commission or the authorized representative shall place a stop order not exceeding 72 hours on any account or transaction if it is discovered that such account or transaction is suspected to be involved in any unlawful act. If the acknowledgement of receipt is not accompanied by a stop notice, or where the stop notice has expired and the order specified in subsection 8 to block the transaction has not reached the financial institution or designated non-financial business and profession, it may carry out the transaction. Where it is not possible to ascertain the origin of the funds within the period of stoppage of the transaction, the Federal High Court may, at the request of the unit or the commission or their authorized representative, order that the funds, account, or security referred to in the report be blocked. An order made by the Federal High Court under subsection 8 shall be enforced forthwith. A financial institution or designated non-financial business and profession which fail to comply with the provision of subsection 1 and 2 commits an offense and is liable on conviction to a fine of 1 million naira for each day during which the offense continues. The directors, officers, and employees of financial institutions and designated non-financial businesses and professions who carried out their duties under this act is in good faith shall not be liable to any civil or criminal liability or have any criminal or civil proceedings brought against them by their customers. Unlawful activity as used in subsection 1E has the same meaning as assigned to it under section 18 subsection 6 of this act. So let us analyze what we've just read. Let's look at the provisions of section 7. If you look at section 7 subsection 1 to E, you see that a huge responsibility has been passed on to financial institutions and non-financial business and profession. They are required to identify transactions that are deemed to be suspicious. How many banks in Nigeria or non-financial business and profession in Nigeria that has a fraud team? As of today, I don't know of any banks that have a fraud department. So how will the bank and the non-financial business and profession identify suspicious transaction? It means that cashier at the bank sees a transaction, he is required to determine in his own opinion, which is a subjective test, that this transaction looks suspicious. Or someone goes to buy a vehicle and the cashier or the customer service advisor deem this to be a suspicious transaction, and they are required to carry out investigation and pass the information to the EFCC. What does the EFCC do? Nothing. They just sit on their backside, and the banks that are not trained to investigate a financial crime, they are now required to investigate transactions and determine what is and what is not a suspicious transaction. And if you look at E, it talked about in the opinion of the financial institution and non-financial business and profession involves the proceed of crime. How can a financial transaction be a proceed of crime if there is no proper investigation carried out. In order for you to determine that these funds is from a proceed of crime, you first of all have to establish that there was a criminal activity. So, for instance, someone is charged, say, fraud, and in that person's account he has a huge sum of money, let's say about 50 million naira in his account. The fact that you've convicted that man for the crime that he committed, that is the fraud, doesn't automatically means that the funds in his account are proceeds of crime. You have to prove that the person cannot, based on his job, income, amount such wealth. So there is no other explanation as to how he acquired that 50 million. That is what you have to prove. So you cannot sit down in your office and someone walk in and you conclude that that amount of money with that person is proceeds of crime. You need a specialist unit to determine a transaction being proceeds of crime. And now this legislation putting a burden on banks and non-financial institutions and profession to carry out investigation to determine in their own subjective opinion what is and what is not a proceed of crime. And then you look at the time limit that they've given them, that within 24 hours, a financial institution and non-financial business and profession shall within 24 hours after the transaction referred to in subsection 1, they have to draw up a report. Why would they be drawing up a report? A report of what? That someone walked into the office, brought 10 million in cash to come and deposit or to come and buy products. Why would they be required to draw up a report? Who is required to draw up this report? Is it the manager of the bank? Is it the cashier? Who is required to draw up this report? Why I am against the procedure that this bank and non-designated financial institutions are required to go through. I believe the intention of this legislation is good, but the burden placed on the financial institution is too much for them to cope. Because if you look at the banks in Western world, they have a compliance department, they have a financial fraud team. If a cashier finds out that there is suspicious in an account, they flag it up to their fraud team. They are specially trained to deal with suspicious transactions. They have the required skills to deal with suspicious transactions, not the cashier behind the desk. And also they have the compliance who are abreast the law and understand what they are required to do in working with their fraud team. Also, the customers are protected by the banking regulators, who is independent and hear complaints from consumers or customers when the bank gets it wrong. The bank does get it wrong, but in Nigeria, who are supposed to be the regulators of the bank or non-designated financial institutions, for the bank, I know that the Central Bank of Nigeria is the banking regulator. But what do they do for the public or the customers? Nothing. I had an experience recently. A transaction that I carried out was double charged within the account, and this matter was reported to the bank. The bank delayed the process, and at the end, they requested me, this is the business, can you contact them to have them return the money, because the money was charged twice and evidence was provided to the bank, and the bank did nothing. I, the customer, was the one chasing the company that I had dealings with to return one of the payments that were placed on the account. And it was quite disappointing. And at the end of the day, the fees that the bank charged me for the transaction was never returned. The company returned the amount that they took, but the fee that I was charged by the bank was not returned. So I was out of pocket as a result of the bank's inefficiency. Whereas if you're talking about the Western world, if you are aggrieved by the act of your bank, you go to the regulators and they penalize the bank for inefficiency. And that alone prompts the bank to do things so that the customers don't go to the regulators because they know that they will be penalized should the regulator find them wrong in terms of the acts that they've carried out. And also, there is a liability on the financial institution and non-designated financial institution should they be convicted. There is a fine of 1 million for every day that they have committed this offense of not carrying out the investigations and reporting that they are required to do under this section. And also the employees could face criminal or civil proceedings against them. Why would an employee be sued or brought criminal charges against? They are working for the bank or non-designated institution. So the employers are vicariously liable for the acts of the employees. By even suggesting that employees could be held liable for their action, it's, in my opinion, giving the employers the get out of jail free card to blame their employees for any actions that they've carried out, rather than train up the staffs to be able to understand and be able to spot transactions that are questionable. I hope you've enjoyed the analysis of these sessions. Next time, we are going to continue analyzing the other sections. We've stopped now at section 7. We'll be looking at section 8. In the meantime, as we get into the election period, the intention is to look at the Electoral Act of Nigeria and also consider some of the aspirants, especially the presidency and some legislative positions, and if possible, look at governorship positions as well. Let's scrutinize these candidates that are asking us for our votes, because we don't want to continue in this trend. We want to bring about change, and the only way we can bring about change is by using our power, which is our voters card, to support that candidate that will bring about change in this country. So, subsequent episode, we may be looking at the electoral process. I did mention at the beginning that we are going to be looking at the new currency has been introduced by the central bank. Given the time, we will not be able to look at this on this episode, but I promise that we will look at it definitely in the next episode. I expect to see your comment. I expect to see you clicking on subscription. I want you to subscribe to this space in order for you to have notification when we upload a new episode. I believe you have had clarification of the sections that we've looked at on this episode, and I will see you next time. Take care now, and bye bye.